Dr. Babasaheb Ambedkar Open University.
Hello and welcome to my dear student to Dr. Babasaheb Ambedkar Open University Ahmedabad in the Chaitanya studio of Dr. Babasaheb Ambedkar Open University Ahmedabad in the video lecture series of the course called the Post Graduation Diploma in Finance in paper number 202 Security Analysis and Portfolio Management, block number 1, unit number 1. Let us continue our subject, or we can say our unit, with respect to the different point of time. As we learned in a previous session, that is what is business, different classification of businesses, then the form of businesses, share, what is dividend, etc. So these are the very important in nature. So let's begin our today's session, that knowing your rights as shareholders. Now the first question in your mind, that is, what is shareholder? And what do you mean by then knowing your rights as a shareholder? So in that first point, that is level of ownership right, in that it is found that there is a hierarchical structure of rights that carries the three main classes of securities which are issued by the companies. Say for example, bonds, stock and common stock. And in case of the common shareholders, at the time of insolvency proceeding, it will be the creditors who first get margin of company's assets so as to settle outside the debts. So it is seen that the bond holder will crack first at those the level 4, the leftover that which is the further followed by the preferred shareholders along with the common stocks, or we can say the common shareholders. So the rule of absolute priority and the right differ with the class of securities, and the right of bondholders are shown differently as a bond agreement, or we can say in a debenture, the display, the contract which exists among the issuer and the bondholder. The next is risk and rewards. As per the liquidation, the preference share holder will able to take more risk, but they have more reward potential by the means of which the exposure to the share price during the success of company. Now let us examine the common shareholders' rights. The first right is voting power on a major issue. In this, the election of directors and proposal for changes which affect the companies in such a way that results in a merger or liquidation. And the part of voting will take place at a company's annual meeting. Then the ownership in a portion of company. In case of business thrives, the common shareholders having a part of something that has certain value shows claim on the portion of asset which belongs to company, and the profit engaged, or we can say the profit gathered by such asset is reinvested in additional asset for the further return, which result in an increase in a share value of the stock. The third point, the third right is right to transfer ownership. The right to transfer ownership is ordinary where the liquidity is provided by the stock exchanges, and it is the key factor which differentiate stock from the investment like real estate. The next right is, my dear friend, that is a dividend entitlement. The dividend entitlement, in that, with the claim on the asset, a claim on the profit is paid by the company in the form of dividend. The management has the two options, with profit and reinvested back into the firm, or the paid out the dividend. So they have the dividend entitlement also. The next right is, my dear friend, that is a suing for a wrong act. Taking the legal action against the company is usually in the form of the shareholder class of action, that is a lawsuit. Another right is, my dear friend, that is a corporate governance. In addition to it, the 6 basic rights of the common shareholder, it is the vital that you thoroughly research the corporate governance policy of a company, and this policy are often to the crucial in determining how the company treats and inform its shareholder. The next right is, my dear friends, that is shareholder rights plan. Instead of a name, such plan differ from a normal shareholder right which are shown by the government. And the shareholder rights plan outline the right of a shareholder in a specific corporation. This is also one of the right. The next right is, my dear friend, that is a sometime there are the little extra. It is seen that shares are used to refer the stock of a corporation, which ultimately shows the ownership of the other classes of a financial asset like a mutual fund, etc. So it is the unit of stock that represent the ownership in a corporation. So these are the, my dear friend, rights over there. The next point is, my dear friend, that is a board of director. A group of individuals that are elected as or elected to act as a representative of a shareholder to established corporate management relating to the policy and to make a decision on the major company issues. And such issues including the hiring or firing the executive, dividend policy, option policy, and we can say the executive compensation, everything, each and everything with relating to the company's management. And that every public company must have the board of directors. And in a general, we can say that the board make the decision on your behalf for the company in which you invest. And most importantly, my dear friends, the board of director should be a fair representation, should make the fair representation of both management and shareholders' interest, because too many insiders serving as the directors will mean the board will make the decision more beneficial to the management. In other words, we can say that, or we can say that on the other hand, to possessing to the too many independent directors and may mean the management will left out the decision making process and may cause the good manager to leave in a frustration. So to making an appropriate decision is one of the important aspect while you discussing the board of director. And in the relation of a company, a director is an officer, that is someone who works for the company, charged with the conduct and management of its affairs. And a director may be an inside director, that is a director who is also the officer or promoter or both, or an outside or independent director. So the directors collectively are referred to as the board of directors. And sometimes the board will appoint one of its member to be the chair of that board of directors. So in that next point, that is a classification, my dear friends. In a classification, the directors are traditionally divided into the executive director and non-executive director. And broadly, the executive directors tends to a person who are dedicated the full time to their role in a relation to the management of a company. The non-executive directors tend to be the outsider brought in their expertise and to lend the more imperial view in relation to the strategic decision. And many corporates, we can say the many corporates reforms in the late 1990s and the early 2000s were focused on increasing the number of and the role of the non-executive directors. In a public company, if we can say in a belief that the imperial view was the more likely to restrain the corporate excess and the egos and to reduce the likelihood of another major corporate scandals. This view is not new. Similarly, recommendations were made by the Cadbury Committee in the United Kingdom in 1992. In a practice that the executive director tend to dominate the board meeting, and simply by the virtue of their much we can say the greater familiar with the company and its internal working. So some countries also classify the person who are not actually director as either the de facto directors or the shadow director. And a de facto director is a person who is not actually appointed as a director but act as if they were. Yes or no, my dear friends? So this is all about that classification of the board of directors. Then election and removal. Legally, the appointment and the removal of director depend on the voting of shareholders that happens in a general meeting. In such case, director can only leave office in case of the registration or a death. Sorry, we can say the resignation and or the death. And sometimes may the jurisdiction allow the board of director to appoint directors in order to fill the vacancy that arises due to the resignation or death of existing directors. And it is seen that it is difficult to remove director by the resolution which held in general meeting. And the legal system will allow the directors to have a right to receive the special notice of resolution that state the removals in which the company supply a copy of proposal to director. Next is exercise of power. The power to exercise by the board of directors occurs in a meetings. The legal system allow the notice that serves to all directors about such meetings and the quorum shows before any business organization. And normally a meeting is held without notice having been given as long as all the directors attend. But it has been held that the failure to give the notice may neglect the resolution passed at the meeting, and as the persuade the authority of the minority of directors might have pursued the majority to change their minds and what otherwise. Next is, my dear friend, duties. The directors exercise the control and management over the company, but the companies are running for the sake of getting a benefit of shareholders, with which the certain law imposes that they carries a strict duty on a director in relation to exercise their duties. Next is remedies for a breach of duty. In the certain instance of a jurisdiction, the law provides the various measures that occur in an event of a breach by the director of their duties. Like the first, that is an injunction or the declaration, the damages or the compensation, restoration of a company's property, then the rescission of that relevant contract, then account of profit, then summary dismissal. So next topic is, my dear friend, that is an annual general meeting. A mandatory, the yearly meeting of shareholders that allow the stakeholder to stay informed and involved with the company decision and working. So first, let us define that meaning and definition. This yearly the meeting, the yearly meeting is a single event whereby the shareholders are able to gather and ask the board of directors questions pertaining to the corporate health and strategies, and the proper notice must be given in the shareholders with regard to the meeting times and agenda. Then, my dear friend, annual general meeting. An annual general meeting, that is a commonly known as the AGM, that is a short form, is also known as an annual meeting. Is a meeting that official bodies and the association involving the public are often required by the law to hold it. And an AGM is generally held every year to inform their member of a previous and the future activities. In organization run by the voluntaries or a paid committee, the AGM generally the form, we can say the forum for the election of officer or the directors for the organization. So we can say that in AGM, the board of directors may be chosen from it or may be elected. It is the opportunity for the shareholders and the partner to receive the copies of company's account as well as reviewing the fiscal information for the past year and asking any question regarding decisions of that particular business will take in a future. So it's the most important elements for defining that any decision making process. The next topic is, my dear friends, that is a preferred stock. The capital stock having a priority over a corporation's common stock in a distribution of dividends and the often of asset. A class of ownership in a corporation that has a higher claim on the asset and earning than the common stock. The preferred stock generally has a dividend that must be paid out before the dividend to the common stockholder, and the share usually do not have voting rights. The precise detail as to the structure of a preferred stock is specific to each corporation. However, the best way to think of the preferred stock is as a financial instruments that has characterized, or we can say of the both, like the debt that is a fixed dividend and the equity that is a potential appreciation is known as the preferred share, or we can say the preferred stock also. The common types of the preferred stock, that is the first, that is a cumulative preferred stock. then non-cumulative, then convertible, then non-convertible, or we can say that the exchangeable and the participating. In the first point, that is a cumulative preferred stock. In that, my dear friends, if the dividend is not paid, it will accumulated for the future payment. The non-cumulative, that is dividend for this type of preferred stock, will not accumulated if it is unpaid, and very common in a trip state. And the bank, the preferred stock, since under the BIS rule, the preferred stock must be non-cumulative if it is to be included in the tier 1 capital. Then, my dear friend, convertible preferred stock. This type of preferred stock carries the option to convert into a common stock at a prescribed price. Then exchangeable preferred stock. This type of preferred stock carries the option to be exchanged for some other securities upon a certain conditions. Then participating preferred stock. This type of preferred stock allow to the possibility of additional dividend above the stated amount under a certain conditions over there. So this is what, my dear friend, all about that preferred stock and the different type of the preferred stock. After watching this video, after completing this video and this particular unit number 1, you have to justify yourself with these 3 aspects. First is a long question, second is a short question, third is a multiple choice question, and fourth is, if you want to read more, then you may refer the different reference book as given. So in that, the first aspect, let us examine the long question. The first question is, write a detailed note on the board of directors. In that, my dear friends, you have to write the meaning. You may write the introduction, meaning, that the definition, or we can say that the powers, duties, remedies, classification, etc. Then write a question number 2, that is, write a detailed note on the level of the ownership rights. In that, you have to define each and everything with respect to the ownership rights. In a short question, what is preferred stock? And what is AGM, that is annual general meeting? You have to write a short question. Then you have to solve these 3 multiple choice questions. In that, the first question is, the interest of a board of directors for management, shareholders, both or neither. So answer is, my dear friends, both management as well as shareholders. The second question is, in a company's annual general meeting is normally conducted once in a quarter? No. Once in a year? Yes. Once in a half yearly? Cancel? No. Once in a 2 years? No. Answer is once in a year. Then multiple choice question number 3, that preferred stock is also called as a preference stock, or we can say the preference share also. So this is what, my dear friend, all about that third aspect, multiple choice question. Then if you want to learn more, you want to refer more, then you may refer these books also. So nutshell, we conclude here our session with respect to this particular video. Here I completed the unit number 1 of your paper number 20. Hope you learn well in this particular video. All the best for your exam, all the best for the learning. Thank you very much, my dear friends.